Hello, I'm David Kemp. South Coast Television is going to look at an ultra-vires motion which was carried and supported by Council. An ultra-vires motion is a motion which has no authority for Council to make. It can be deemed to be illegal.
Question on notice 19.1 deals with the Crozier Hill Estate. That's from Councillor Charles. A recommendation that Council note the information and commentary provided in this report regarding Councillor Charles' report titled Matters Arising in Connection with Crozier Hill Estate, Victor Harbour, presented by Councillor Peter Charles in the City of Victor Harbour Council on the 26th of September 2016, and that no further response to the report or the questions posed be sought from administration. Someone like to move that way, thank you. Councillor Jenkins, thank you. Councillor Chigwidden, seconding. Open for discussion. Anyone against?
Excuse me, Mr Mayor, I respectfully raise a point of order.
What's your point of order?
Point of order. Who set the motion? Was Councillor right? This motion is not in keeping with the provisions of the Act, and I ask that Councillor Jenkins retract her support for the recommendation, as is clearly ultra vires. With regard to the final 16 words they are, that is the 16 words of the recommendation, and that no further response to the report or questions be sought from administration. This is an unlawful attempt to circumvent the Local Government Meeting Procedures Regulations and the Local Government Act of 2002. Elected members, as we know, this part of the Act under the heading of Section 9, Questions and Subsection Regulation 1, a member may ask a question on notice by giving the Chief Executive Officer written notice of the question at least 5 clear days before the date of the meeting at which the question will be asked. If notice is given under subsection 1, which is what I just read, then part 2A, the Chief Executive Officer must ensure that the question is placed on the agenda for the meeting at which the question is to be asked, and part 2B, the question and the reply must be entered in the minutes of the relevant meeting. Members, we all will have to turn our minds to the fact that the Act means what it says. That is, according to the information I shared reading from the Act just a minute ago, if the questions are placed in the agenda, and they obviously have been, then it is unlawful if they are not answered in the minutes. Therefore, so as not to act unlawfully, in 5 days these questions should be answered and printed in the minutes. I also remind members that Part 4, Section 91 of the Local Government Act, Point 3, each member of the Council must, within 5 days after the meeting of the Council or Council Committee, be supplied with a copy of all minutes of the proceedings of the meeting kept under this section. As you would know, Councillors, Section 9, Part 2.6 is quite clear. The presiding member may rule that a question, with or without notice, not be answered if the presiding member considers that the question is vague, irrelevant, insulting or improper. In simple terms, these 4 words which describe the intent, real or perceived, are the only reasons upon which answers will not be provided lawfully. Note the questions are asked, but in the assessment of the presiding member, the decision to answer or not is vested. There is no provision in the Act to remove the lawful right of an elected member to put questions to administration, and no provision for administration to not provide answers, unless the questions are once again deemed vague, irrelevant, insulting or improper by the presiding member. Mr Mayor, you are the presiding member. How say you?
Thank you for that, but I will point out that the questions deal with a subject matter which Council has already ruled not to receive information on, and it's my recollection that the information you passed to me was just on the end of the last meeting and was just handed there with no comment from Council. I'll be guided by our CEO on that matter. Is that your recollection of the last meeting? That was handed?
Well, Well, through you, Your Worship, I think Councillor Charles probably raises more questions than answers at the present time, and perhaps it is best for Council at this point in time to adjourn this particular item, receive Councillor Charles' professional legal opinion, if that's where he's got it from, and for Council to seek its own legal advice on how we can proceed with this matter.
Thank you. Yes, Councillor Marshall?
I can't believe what I'm hearing. I think every elected member in this council swore an oath to look after the interests of the ratepayers. For someone to try to tell an elected member of this council that there are certain questions they just can't ask, I think is just reprehensible and beyond the joke. I don't think they need to seek legal advice. Why do we always have to go and spend money on legal advice? Yes, about the rocks, that's good value, but not about this. What concerns me is the end of the motion that says, and that no further response to the report or the questions posed be sought from administration. Now, does that refer to elected members? Does that refer to members of the public? Who does it to the media? Who does it refer to? I mean, you're trying to say here that we are omnipotent. We are not going to listen to your questions, and that's it. And I just think that's totally wrong. And if anyone believes that, well, I think they need to put in their resignation.
Now let's look at how this recommendation was put to Council.
My motion that is any future matters in regard to Crozier Hill Estate and the floodplain be referred directly to the Ombudsman's office and not dealt with in Council. The reason for that is that, as Councillor Chigwidden said, this matter has been dealt with for a number of years. Council has had a full briefing on this matter. When we came to Council, Peter Charles talked about that. There's hundreds of questions that have many been answered before. I think when I was looking through the questions for this agenda, there's a number of questions in both item 4.1, item 19.7, item 19.5 that are exactly the same question that have been asked on a number of occasions. This is just, I think irresponsible to keep bringing something to Council until you get the answer that you want, when you know that the answer's not what you may agree with. So I think that given the matter, it needs to be referred directly to the Ombudsman. Can I just add to that, Your Worship, which might clarify something? Given that amongst these questions are concerns by Peter Charles and the people that help him write these documents up, that there's maladministration that occurring in the Council in relation to this, that Peter Charles certainly, one of the things he said in his first motion was that there is a guilty demeanour amongst Council. If that's the case, then it needs to be reviewed by an independent third person who is the Ombudsman. And I think if these questions go to the Ombudsman once and for all, we'll get clarity.
Thank you. My concern, which is what I've discussed with the CEO, the Ombudsman needs to have some sort of allegation he has to deal with. Sometimes that's very apparent, but in this case it may be wise just to put it through to the Ombudsman to get some sort of feedback on it. But so I'll let the motion stand. Anybody wish to second that motion?
Your Worship, can I just clarify something that you've said? While the Ombudsman may need a complaint, I think that given the degree of questioning and the type of questions that are coming here, there may not be overtly a complaint of maladministration, but there is certainly underlying all of this covert complaints of maladministration by Council.
Thank you. And possibly the Ombudsman will send it straight back if there's no issue there. So looking for a second on the motion. Councillor Chigwidden, thank you. Did you want to speak to seconding? Open for discussion. Yes, Councillor Marshall.
Well, it's no surprise I'll be speaking against this very strongly. Councillor Jenkins is all very clever, but she's only been here for 2 years and she has got had no access to previous information that had been supplied to Council on several occasions. She's only relying on what someone else has told her, not from a personal experience. I believe that this motion is ultra vires because it's stopping an elected member from doing his or her job. Doesn't matter whether it's Councillor Charles, whether it's me, Councillor Andrews, Councillor Hayles, anybody who asks a question about this will be told we're not answering it. And I don't think that the council's got a right to do that. It may not like the democratic process, but the democratic process is there, and it's there for everybody to use, and nobody should be stopped from doing it. This place is getting like Stalin with Russia, because we're being told we can't ask questions about certain things. We're being told that the mayor is not going to entertain the question because it's vague or insulting or some rubbish, and it's just stopping elected members from doing the job they're elected to do. So, as far as I'm concerned, this is ultra vires, and I'm sure it'll be found to be so. You can't make up these sort of motions on the run without doing your homework.
Thank you. Any other discussion? No other discussion. Councillor Jenkins, close the vote, yes?
Just in closing, I'm surprised that Councillor Marshall is speaking strongly against this, because I would have thought that he'd like to have an independent assessment of these questions. I'm more than happy for councillors and anybody to ask questions. However, these questions have been asked numerous times before. They've been answered numerous times before. As Councillor Marshall said, prior to us coming to council. They've been answered in emails, they've been answered in councils. There's over 100 pages of questions. This is getting ridiculous. So by all means, the democratic process needs to prevail. But when questions have been answered and somebody keeps asking the same questions in order to get a different answer, and those questions are insinuating maladministration, then I think we need to go to an independent review and get this finished with once, so that council staff stop getting badgered, and also council staff are able to get on with their job and actually do the work they're being paid for.
Thank you. That closes the debate. Everybody understand the motion? Okay. All those in favour? And those against? That's carried. Thank you.
As you can see, this matter is quite involved. CEO Graham Maxwell reports back to Council on his findings in a conversation with the Ombudsman.
I asked the CEO essentially for an opinion on whether the motion moved by Councillor Jenkins was ultra vires. And the reason that I asked that was because I strongly believe it is ultra vires. There are two parts to it which I think are both beyond the powers of Council, ultra vires. And I also wanted to highlight the dangers of making up motions on the run and getting them wrong. You need to sit down and think about motions before you just make up something in most cases, and instead of just chucking it the first thing that comes up. So no, the question has been answered. I mean, I don't know whether I have to put it so plainly that the grade 1 kid could understand it, but my question is clearly, was that motion ultra vires? And I haven't had a response. We've gone off on a tangent, we've raised other issues, we've talked about the CEO not being able to get a word in to tell the mayor that I assume that he thought it might be a problem motion. Yet we've seen tonight that the CEO is able to get a word in when he wants to. It's just, I don't know what's going on with this, because it'll make us a laughing stock if the mayor accepts ultra vires motions and the CEO at the time doesn't raise the issue or draw it to his attention. So, no, I'm quite concerned that essentially the CEO has refused to answer the question, in my view, and so it'll be put up again at the next meeting.
Thank you for your accusations. Yes, Graham?
Well, firstly, Your Worship, I object to Councillor Marshall referring to questions he poses to me needing to be framed in a grade 1 level. I think that's totally offensive and totally inappropriate. And I think if you read my full report, I did answer your question in the last paragraph, which actually said legal advice is not necessary at this stage, as it was quite clear to me that the motion had legal and practical application challenges. What the motion does provide, albeit ultra vires, is a reason to exchange dialogue with the Ombudsman about the circumstances surrounding this whole issue, which with a view to extracting some advice. I'm pleased to say, Councillor Marshall, that I've had that discussion with the Ombudsman on Thursday, and he concurs with both yours and my view that the motion was in fact ultra vires.
Well, thank you, Mr. Maxwell, but why don't you just say yes, the motion is ultra vires?
Perhaps I'll have to put it in simpler terms, Councillor Marshall.
No, I've read it. I, like you, can understand grade 1 stuff. But, you know, I don't think that you could have just said it in clear words, yes, the motion was ultra vires. And it's not said in clear language that most people can understand.
What will the current administration do about this motion? We have presented the facts. You make up your own mind.
This has been a South Coast Television production.